On Thursday, January 26, 2023, John Fitzgerald Johnson, known as Grandmaster J, appeared in Louisville, Kentucky State Court by teleconference and entered what is referred to as an Alford Plea to 5 more counts of wanton endangerment levied by the state in addition to federal wanton endangerment charges which he was indicted for in February of 2021, and is already currently serving a federal prison sentence for the exact same incident. By entering the so-called Alford Plea, Mr. Johnson maintains his innocence but acknowledged that prosecutors may, especially in lieu of the federal conviction, have decided that there was enough evidence for an additional state conviction against him.
For the record, that's the identical thing I sent to him and that he and I discussed.
Okay, thank you. All right, Mr. Johnson, do you have copies of these documents in front of you?
Your Honor, I have the documents in front of me. I've had them for a few weeks. I've read them in detail. Everything that I've heard on this call so far reflects exactly what's reflected in the documents, including the Commonwealth's offer, the conditions of the offer, and the subsequent discussions that I've had with Mr. Lambertus. Also concurs with everything that has occurred. I have these documents here in front of me.
Thank you. I appreciate that. Before I can accept your plea here today, I need to place you under oath and ask you a series of questions. First, to make sure that I do have the right person in front of me, then to make sure that you are fully informed and thinking clearly, and that you understand your constitutional rights. I understand that you are entering your plea pursuant to North Carolina versus Alford, which has the legally the exact same effect as a guilty plea, but instead of admitting your actual guilt to the facts of the case and these charges, what you are admitting to the court here today is that if you went to trial on these charges, that the Commonwealth, with the evidence that they have and would present at trial, may be able to achieve a guilty verdict.
The prosecution recommended a 1-year sentence for each of the 5 state wanton endangerment charges, to be served concurrently with the federal prison sentence as opposed to consecutively or in addition to the federal sentence in exchange for the plea. We agreed it's in his best interest to do this, said the state attorney representation.
Guilty plea pursuant to North Carolina v. Alford. What is the Commonwealth's recommendation in this case?
Judge, the Commonwealth is recommending that for each of the 5 counts of wanton endangerment in the first degree, the Commonwealth would recommend a sentence of 1 year, those to run concurrently for 1 year to serve. No motions for probation or shock probation. The Commonwealth recommends this sentence run concurrently with the defendant's federal sentence, and then there's a case number included that was tried in federal.
The incident that allegedly took place happened during a peaceful public protest led by Mr. Johnson in 2020 because of the wrongful death of Breonna Taylor at the hands of police in her home. Mr. Johnson was accused of multiple federal and state charges of wanton endangerment during the armed protest in the open carry state of Kentucky. Despite the fact that experts have demonstrated why it was not likely possible for Mr. Johnson to have seen who was on the roof from his faraway position on the ground at night, explaining why it made sense for him to have been simply shining his flashlight from his gun instead of brandishing it in a threatening manner, and that Mr. Johnson has maintained his innocence throughout the case. He was still convicted in federal court and charged additionally with these multiple wanton endangerment counts by the state. Ironically, wanton endangerment was the same charge made against the only one of 4 officers to be accused criminally in the Breonna Taylor case initially, except the officer was only charged with a single count, then found not guilty at the time.
Okay, fair enough. All right, those are all the questions that I had for you. Now I'm going to go over the facts of the case as they are stated in the plea sheets. And in paragraph 4 in the Commonwealth's offer on a plea of guilty, the facts of the case are stated that on or about September 4th, 2020 in Jefferson County, Kentucky, the defendant manifested indifference to the value of human life and created a substantial danger of death or serious physical injury when he pointed an assault rifle at 5 police officers stationed on the roof of the old jail building. As I discussed at the beginning of this plea, you are entering your plea pursuant to North Carolina versus Alford. So I understand that you are not admitting actual guilt on these facts, but that you agree, or let me ask you, do you agree that if you went to trial on these cases, the Commonwealth has evidence such that they may, a jury may return a guilty verdict on those facts and evidence?
I agree with the fact that the possibility is very high, based on the evidence that there is a very strong possibility that a guilty plea would be returned.
Okay.
The judge accepted the recommended plea and expressed her understanding that John Fitzgerald Johnson was not admitting to any actual guilt regarding these charges under the North Carolina Alford Plea. An Alford Plea, also called a Kennedy plea in West Virginia, or the Alford doctrine, is a plea in criminal court, whereby a defendant in a criminal case does not admit to the criminal act and asserts innocence. It is also known as a best interest plea, thus concluding Mr. Johnson's over 2-year arduous journey through the Kentucky state courts. Mr. Johnson's representation is expected to appeal his conviction,